What the heck's going on?
Ms. Sarfarazi,
Yes.
good morning.
Good morning.
Is Ms. Smith going to be joining us this morning, or?
Yeah, she's under. It says undefined or unnamed
Oh,
she
okay.
can't give her name to say her actual name.
Okay, all right. I will make her a panelist. Thank you.
Awesome. Thank you.
Morning, just making sure you can hear me.
We can. Thank you, Ms. Smith.
I don't know.
Calling on.
Gotta unmute you from over here. You're on mute
Your
now.
Honor.
Good morning.
Oh, okay.
You got, you have to.
I didn't do it.
Okay.
All right, so I think everybody can hear me now. I just want to let y'all know, we've been in touch with Department of Corrections. We're still waiting on them to log on. So as soon as they come on board, we'll get going. All right, Ms. Smith, I think you're muted. I didn't get any of that.
Okay, sorry. I get it backwards, sorry. I think we're down to 2 cases anyway, one with a witness, the other, we have opposing counsel. He was gonna ask for continuance. I don't know that he has. But I think our witness is online, so we're just happy to be here.
You may be fudging a little bit with that. Let's see. I've got some notes from my assistant.
I don't think so.
Apparently, Mr. Zell had a motion for new trial in Fulton County today.
Well, I had a long county that was 10 a.m. But I don't think I sent him anything that said that.
So he was not going to be available. And then
I don't know, Heather. I talked to him yesterday, to Rhonda.
Judge, apparently there was some confusion. They thought that we, like the Middle Circuit, began at 10 a.m. rather than 9. So that's why they're not on, but they're connected.
tell him that's a pitiful excuse. We've got 3 max security prisons in this circuit, and the Middle Circuit has what? 1 2-cell detention facility. So they're going by the Middle Circuits. I've just been told the Department of Corrections thought that we started at 10 rather than 9. If I were chief judge, which I'm not, I would be in touch with them to assure them that we start at 9, so that they wouldn't have any confusion in that regard, but I'm not, so we'll just trust that we'll get word out there to them somehow to tell them that we start at 9 o'clock, but apparently they're gonna be available at 10 o'clock. I mean, I've been doing this for 15 years. That's the first time I've ever heard them be confused about what time we get started, but apparently they are.
Just go ahead.
I will pass that along to our client, Judge, because I know Ms. Corbett is no longer with us, so we've had a change, but I'm with you. It's always been 9 o'clock or even when it was Judge Harvey.
I
So.
had left it saying 10 a.m. because of that long, but.
Back when Miss Rachel was the court reporter.
Can you forward?
Absolutely.
By the way, she's been
These are the
she
notice of
texted me this
electronic
morning
hearing that
as I was
we
driving
sent
in
out
the
like a
court
month
to tell me
ago.
that.
Yeah.
And they're in the record and
Pine straw is falling, and she has it
On every
raked up.
case
I need
today.
something to go around my shrubbery. So,
I mean,
at
I
84 years old, she's still raking straw and picking up pine cones and sticks in her yard and doling it out between me and my siblings.
Yeah.
I just sent them
So there's
that
no
one,
arguing
so I don't
and
think they
backbiting
got
about who's his
confused.
favorite
Because it's
child.
10 a.m., but that's Long County.
Well, okay, and the clerk's notices say 9. I don't know.
I don't know
I
what
spoke
would
with
have
Habeas
said 10.
and the deputy.
For one of the.
Our calendar
Do
says
not
10.
And he is
know
going to let us know
how
that he's not
the
gonna be.
Hope
confusion.
it's not something that I can't find.
Okay.
He's got medical. I don't know,
Possible. I spoke with Habeas attorney.
He's
I think he's,
apparently Mr. Shepherd represents Lorenzo Wells. Mr. Shepherd contacted our habeas clerk yesterday. Unfortunately, apparently he has cancer and is undergoing chemotherapy treatments, and because of I'm assuming this, but he is ill, and because of that, he is not going to be prepared to go forward today.
Thank you, Judge. We had anticipated that. We just hadn't heard that he had done that.
Okay. I don't think we didn't hear from him apparently until yesterday,
That's
so
right.
kind of late notice, but with him being sick, that's understandable, so no harm, no foul. We'll just take that off the calendar.
Thank you. That leaves Ms. Safarazi. I don't know if you've met her yet. She's handling the McFarland case where we do have a witness.
Okay. All right, good morning.
Good morning, Your Honor.
How are you?
Good, how about you?
I'm fine. I'm sorry, what was your last name?
Safarazi.
Okay, just as it is on the screen. Say something else and it'll be appear on my screen. There it is, Sarfardz. All right, and you represent Mr. McFarland. So as soon as McFarland's available,
She's with the AG's office.
oh, you're with the AG's office. I'm sorry.
Yes.
You don't,
I can go out and call Rhonda Tillman. Have you talked to her?
Yeah, I'm corresponding with her.
Go ahead and join.
I've asked her. She said that the problem is bringing the inmates down. I mean, they can turn the equipment on, but
He won't be there yet.
they're gonna have to bring the inmates down and all that stuff. So she said, we'll do it as soon as possible, but it may not be
Okay.
the next 5 minutes or so.
I thought your selection went pretty smooth yesterday.
I think so too.
Um, All right, you folks at the prison, can you hear me?
Yes,
Okay, all right, what's your name, sir?
Mario Gooden.
You're Mr. Goodens. Okay, let's see.
That's number one.
All right, and you're represented by Mr. Zell.
Yes, sir.
All right, Mr. Zell contacted our office yesterday and indicated that he had a conflict this morning. He was in court or scheduled to be in court in Fulton County today, and he asked that this case be continued. So without your attorney, we're not going to go forward. So we will reschedule this for the next calendar. Okay?
Yes, sir.
All right, thank you, sir. All right, who else do we have there?
I think that's the only person we have from Smith, Judge. The others are Georgia State Prison.
I think, yes, that's right.
Okay, we're in. Okay, we're in.
All right.
Okay, thank you. Good morning.
Good morning, how are you?
Hi, how y'all doing?
Good. Mr. McFarland?
Yes, sir.
Okay, let's go ahead and start with,
Okay. I need to run and go get wheels. I ain't came back with wheels yet. You already standing in between the two doors. Make sure you're answering yes, sir, no, sir, yes, ma'am, no, ma'am. And you may have to take your mask off so they can hear you, okay?
If it's possible, could I take these coats off so I can be able to show them the, if it's possible, could I take these coats off so I can show them, like, my paperwork and my rules of evidence?
all right, good morning, Mr. McFarland, how are you?
I'm doing all right, sir. Good morning. How are you?
I'm good. Court's gonna call case number 2021-18. Found Marvell McFarland, the petitioner, versus Savannah Bobbitt as the warden. Are you ready to proceed?
Yes, sir.
Yes, Your Honor.
Are you ready?
Yes, sir.
Yes, Your Honor.
Okay. All right. If you would, please give a brief outline of the allegations, Ms. Sarfarazzi, contained in the petition.
No problem. So petitioner filed this petition challenging his 2007 Fulton County guilty plea convictions for voluntary manslaughter, aggravated assault with a deadly weapon, aggravated assault, possession of a firearm by a first offender probationer, and possession of a firearm during the commission of a crime. Petitioner has raised, he's laid it out as 4 grounds, but really it's 3 grounds of in his habeas petition, and the third ground is ineffective. That has about 8 claims of ineffective assistance of counsel. And we have his guilty plea counsel here to testify to that.
Mr. McFarland, do you have any witnesses that you wish to call? And you may have heard that the Attorney General's office is going to have your guilty plea counsel testify. I'm going to give you the opportunity to cross-examine that witness at the appropriate time. Are there any additional witnesses that you have under subpoena for the purpose of this hearing?
I would wish to subpoena Alfonso Booker and Steven Jenkins and Kiara.
Do you currently have them under subpoena? And did you?
No, sir.
Okay,
No, sir.
all right. If they're not subpoenaed, we're not going to continue this hearing. We're going to go forward. What I'm going to do is allow Ms. Farazi the opportunity to call witnesses and conduct a direct examination of her witnesses, and at the conclusion, I'll allow you to ask questions on cross-examination. All right?
Yes, sir.
All right, you may proceed. Call your first witness.
Yes, Your Honor. We call Corey Bowles.
All right.
Good morning, Your Honor.
Good morning. How are you?
I'm well, and yourself?
I'm doing good. If you would raise your right hand and be sworn, and I'll administer the oath to the clerk. All right. You swear affirm testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God.
I do.
All right. Thank you, sir. All right.
Hello, Mr. Bowles. Can you please state your name and business address for the record?
It's Corey Bowles. Business address is 3350 Riverwood Parkway, Suite 1900, Atlanta, Georgia, 30339.
And what year were you admitted to the Georgia bar?
2000.
And since becoming a bar member, how have you been employed?
The first 8.5 years, I was an assistant district attorney with the Fulton County District Attorney's Office. Since then, since February of 2008, I've been a criminal defense attorney.
And then, so at the time you represented petitioner, what was the percentage of your practice that you devoted to criminal work?
Probably about 95%.
And how many felony trials have you handled at that time?
Just as a defense attorney?
Sure, yes.
Okay. Probably about 10 to 15, something like that.
And then how many did you handle as a prosecutor?
That was probably another 10 to 15, somewhere around there.
So about 20 trials by that time?
Something like that, yes.
Okay. And Matt, how many guilty pleas would you say you handled as a defense attorney?
Hundreds.
And then as a prosecutor as well?
Yes.
Okay. And then do you handle any appeals in either capacity as a prosecutor? Defense? Okay. And at the time, at what point did you enter petitioner's criminal case?
It was assigned to me as a C3 because there was a conflict with the public defender. Offhand, I couldn't tell you the exact date of my entry though, but I believe it was sometime. It was in 2017. I couldn't tell you the exact date of my entry.
Was it? Was it before the indictment?
No, I believe it was posted.
Okay. And were you appointed or retained?
I was appointed.
And do you recall the facts of this case?
The general facts, yes, I do.
And do you? How did you prepare and investigate for this case?
Well, requested and received a discovery. Spoke to Mr. McFarland about the case. Talked to the prosecutors about the case as well, and basically went through it to see, what the strategy would be, and went from there, really.
And so you said you received discovery. Did you review all the discovery?
Yes, I did.
And that included police reports?
Yes, it did.
And it included photo lineups?
Yes, it did.
Okay. And you reviewed all those?
Yes,
Okay, good. And you said you were able to meet with petitioner,
yes,
and were you able to communicate with him,
yes,
and you were able to discuss all the charges, and he was able to understand that?
yes,
And did you review the discovery with him?
yes.
Okay. And did petitioner provide any defense witnesses?
I believe there was some witnesses that if we went to trial, that yes, he would have had me call.
And you met with them?
I believe I spoke to them about that, but they weren't. If I remember correctly, there weren't eyewitnesses. They were other types of witnesses.
Did you feel like they were helpful? That would be helpful for trial or for your defense?
For the defense, no, not for what the defense would have had to have been.
And so, in all this investigation, were you able to form a viable defense?
In my discussions with Mr. McFarland, we talked about what his defense would be. So yeah, the answer is yes.
And what was your defense?
The defense would have had to have been, according to what I was providing in discovery, is really going to have to be accident.
Okay. And you discussed accident with him?
Yes,
Did you discuss self-defense with him?
we discussed that as well.
Okay. And did you file any pretrial motions or attend any pretrial hearings?
I don't remember filing. I tell you the truth, I can't remember. I know there were. No, it was. I remember mostly that I was uncomfortable with the defense, and I remember talking to the DA, and Fulton County kind of has this policy, at least sometimes some of the ADAs do, that if you're negotiating a plea, that comes before motions. If you start filing motions, then the best plea offer goes away and it gets worse. I remember potential motions as far as suppression of the lineup, but that would have been an ID issue, and I thought that the state was prepared to counteract that. I didn't see any merit in pretrial in any identification or the photo lineup motions anyway. And even had we been successful, the state had a way to counteract that.
So you felt like it was a strategy not to wait on filing any motions.
Right.
You negotiate a better plea.
Right. The only motions I can think of would have been identification. There may have been some motion in Lemony's file, but I don't remember for sure.
Okay. And did you discuss a severance? It was a co-defendant case.
Yes, but he had already been offered. He was offered a plea, a very nice deal, so he wouldn't have been present at our trial anyway, not as a defendant.
And did you discuss the possibility of trial with petitioner?
Yeah, we discussed trial extensively. What I expected what would have happened.
And you discussed the ranges he could get for his sentence, whether he went to trial, just the statutory ranges generally.
Yes. Mm-hmm.
And I want to move on regarding the guilty plea. How did the plea come about? I know you said you discussed pre-trial. You discussed early on. How did the plea come about in the state?
After discussion with the ADA, back and forth for a while, finally they agreed that it should not be a murder case, that he would be allowed to plead to voluntary manslaughter, and kind of went back and forth over what the sentence would be, but finally it was set at voluntary manslaughter. I believe 20 years on that, followed by 5 on a gun charge. So that's what we went with.
So you guys negotiated a plea?
Yes, because he was charged with murder.
Okay. And you communicated that plea offer with petitioner?
Yes.
Okay. And you discussed the rights that he'd be waiving if he did plea?
Yes.
And you discussed the right to trial?
Right.
Right to confront witnesses?
Yes.
And then the right to not incriminate himself?
Correct.
Okay. And did petitioner have an opportunity to ask you questions?
Yes.
And did he ask you questions regarding his rights?
He did.
And whose decision was it to ultimately enter the plea?
Well, it has to be the defendant's position that they're the one that makes a decision. All I can do is give my suggestion and what I would think the pros and cons of taking it would be. But the decision is his.
And that's what happened here.
Yes.
All right, so on to the plea hearing. Since it's a negotiated plea, did the court follow the state's recommendation?
Yes.
And was petitioner advised of his constitutional rights by trial by jury and confront witnesses and not to incriminate himself at the plea hearing?
Yes, he would. And he had to actually sign the boy's rights.
And at the time, were you satisfied that he was entering his plea knowingly and voluntarily?
Yes, I was.
And following the plea hearing, did petitioner ever mention that he wanted to withdraw or appeal the conviction?
I don't remember. We didn't talk again that I remember after that. I could be wrong, but I don't remember talking to him. There may have been some correspondence forwarded to my office at some point, maybe a year later, but I really don't remember for sure.
Okay. So moving on to more of the specific ineffective assistance of counsel claims. One of the claims is that you failed to raise petitioner's sanity. Did you have any concerns regarding petitioner's sanity in this case?
No, not at all.
There was no indication for you to raise that or to bring that to the court's attention?
No, not that I saw.
And did you guys discuss any immunity? That's another one of his claims, is that you failed to counsel him on immunity.
We talked about as far as self-defense.
Sure. Well, let's talk about, I guess, immunity, and then move on to self-defense, just to be clear.
I don't recall any immunity issues that could have been raised other than possibly self-defense. That was it.
And you said before you discussed self-defense with him.
Yes, we did.
Oh, hold on, my light went off. Sorry about that. All right, so, did you also represent petitioner at his bond hearing?
I believe I did, yes.
And he was granted bond?
I don't think he was granted bond, no.
And one of the other claims is that you failed to inform the court that you two had differences. Was there any differences that you felt impeded your ability to represent petitioner?
Differences, no. I mean, of course, there are times where you go back and forth and things get a little, we both get angry.
Mm-hmm.
But I would be telling the court pretty much for every client I have at some point, especially serious cases like this. But there was nothing where we failed to stop working. It was just, there were times where our discussions got heated, but I've never been under the impression that that's something I need to inform the court. It didn't get to a point where we could no longer communicate or stop working together.
Okay. And I think you said this before, but just to be sure, you said you looked into severing, but you decided not to sever due to the plea?
Well, it was already going to automatically be severed. His co-defendant was given a deal totally removing the murder charge. I think he was going to plead to something involving 5 years. And his deal would have required him to testify if Mr. McFarland would have went to trial.
Okay. No further questions.
Do you have any questions that you want to ask the witness? Cross-examination?
I want to ask Mr. Corey Bowles if it would have been permissible for him to sever, being that the identification issue that I raised, and I told him, I said that it was a single photographic procedure that was used by the detective to gain initial identification on 10/18, in which I explained to him, he told me that I was smart, and how did I know that? And he did not go through with suppressing identification. And my co-defendant's statement, it conflicted my defense as identification. That could have been a defense that could have been taken by the attorney. That's one of the questions I want to ask. Why didn't you file for a motion to suppress identification?
I didn't think there was any merit to the identification issue. And again, like I said, your co-defendant was offered a plea where he would have had to testify. all he would have had to do was say you was with him, and that would have killed any identification issues. But as far as the witnesses that identified you, I didn't think there was any merit in, I didn't think we would be successful, I should say, not to say there wasn't any merit. I didn't think we would be successful at any hearing to suppress identification.
Do you don't remember me being granted a bond?
I remember you were in custody during the whole time. But I do not remember you being granted a bond. I do remember you were in custody from the beginning of my representation until you took your plea.
I was in custody over 90 days, Mr. Bowles, and they granted me a bond, and it was excessive against the 8th Amendment. And I requested that I get a bond reduction or something like that, and you never did it.
I don't recall us ever talking about a bond. Every time I met with you, it was more about the merits of the case. I remember us having extensive discussions, bond, not one of them.
Do you remember the time and where I gave you a full Brady versus Maryland discovery pack in Fulton County?
That you gave me, I got discovery from the state, not from you.
I gave you a copy, Mr. Bowles.
You may have given me a copy of something you had. Okay, I don't remember exactly, but I got discovery from the state.
I have no more questions, Your Honor.
Okay. Can you redirect?
No, Your Honor.
I'm sorry, I didn't.
No redirect from the respondent.
Okay, thank you, ma'am. Any other witnesses?
No.
Any evidence that needs to be tendered at this time?
Yes, Your Honor, we have 2 exhibits.
Okay, all right. And Mr. McFarland, just so, and I know you're not represented by counsel in this proceeding, the exhibits that are being offered by petitioner, by the respondent, consist of the record of your case, and you've made certain allegations in your petition. In order for me to determine whether there's any merit to these allegations contained in the petition, it's necessary for me to review the record of your case. And so the exhibits that she is tendering consist of what makes up the record of your case. Okay, do you have any objection to the exhibits being offered by the respondent at this time?
What would you mean by objections, Your Honor?
Do you contest that, or do you contend that there's any, this should not be made part of the record?
I can hear you, Your Honor.
Do you have any basis for, do you object to these exhibits? That's my question to you.
Do I object to the case file?
I'm going to let Ms. Safarzi explain what exhibits that she has.
Yes, Your Honor. Can I share the screen?
Yes, ma'am.
Is it showing? Can't tell. Can you guys see the exhibit?
No.
All right. Can you guys see this?
Yeah, I can see you're sharing an exhibit at this point.
I cannot see it.
That appears to be the plea transcript.
Yeah,
Oh, I have the plea transcript here.
the way she's sharing, Judge, it's making it
while it appears on the computer, it does not on the Cisco system. So I'm not sure if that's the reason that the petitioner is not able to see it, because they use the same equipment that we use. And here on the system, as you can see on the monitors, we're not able to see it. So is there any way you could, previously you were sharing without your picture on the bottom right, and we could see it here. Is there any way you could just share it without having your video of you included? She's gone. Miss Arfarazi, can you hear me? Nope.
Looks like Ms. Smith is going to see if she can help with that. I think we lost Ms. Sarfarazzi.
They didn't email these to you, did Rachel? I mean, if not, I can share them.
They normally don't email me those.
Whoa, I'm going. Yeah, it's telling me it crashed. Okay, let me see if I can go back in.
I think I'm back. All right, bear with us just a minute, Mr. McFarland, while we get the technological issues resolved.
Yes, sir.
There we are.
Still. Miss Sarfarazi, can you unmute yourself? We still can't.
Hello?
Yes,
Can you guys see the exhibit?
Yes, I I can. Mr. McFarland, can you see the exhibit at this time?
Yes, sir, Your Honor, I can't see it.
Okay, thank you.
I'm sorry about that, Your Honor. Technology.
That's okay.
So this is Response Exhibit 1, which includes the let me go to the front. Which includes the indictment. And the sentencing sheet. As well as the entry of appearance, Mr. Biles, and the order of bond.
Any objection to Respondent's Exhibit 1? Mr. McFarland?
I want to object to the indictment, Your Honor, because I had no common sense into pleading guilty to these charges, Your Honor. I didn't have any clue of any sense of law or any sense of defense. I don't recall.
All right, your objection is noted for the record, but it's overruled. The court's going to admit Exhibit 1. Any other?
Sorry, yeah, we also have Exhibit 2.
Right, and this is the guilty plea transcript?
Yes, Your Honor. And it's actually the guilty plea transcript and the transcript of voir dire that happened prior to the guilty plea.
Any objection to Respondent's Exhibit 2?
No, Your Honor.
All right, Exhibit 2 is admitted.
Your Honor.
All right, anything else? Any other exhibits? Mr. McFarland, do you have any exhibits that you wish to tender?
Yes, Your Honor. I have the case summary.
All right, have you previously filed that with the clerk's office, or is that something?
No, this is what was given to me by the clerk of court, Fulton County. This is the case summary of all the motions and all the proceedings that went through court, in which I did go through in court in Fulton County.
All right, let me ask Ms. Sarfarazi, is that included in either Respondents 1 or 2?
No, Your Honor, not the case summary.
Okay.
I also have photographic lineups in which were conducted.
Any objection by Respondent as to Petitioner 1, which is the case summary?
The only objection is we haven't seen it, so I can't verify that would be the case summary to know if it's an objection. We've never seen these exhibits.
Okay. And then you had Mr. McFarland, you said Petitioner's 2 was a photographic lineup?
Yes, Your Honor, and also the transcript, Your Honor.
Which transcript are you referring to?
Case number 17 SC 1519
Is that your guilty plea transcript?
Yes, sir.
Okay, well, that's already in the record. That Respondent has, we don't need 2 copies of that. So here's what I'm going to do. I'm going to keep the record open, give you the opportunity to send these exhibits to the Attorney General's office so they can review them. And after they've reviewed them, if they have no objection, they can notify me and we'll add that to the record. If they do have an objection, we'll go back on the record and deal with those objections at that time. Okay?
I don't understand, Your Honor.
All right, I'm gonna give you 10 days to mail these exhibits to the Attorney General's office. All right? They can tell me whether they have, because they've not seen them. They don't know whether they object to them or not. They've not seen them before. I'm gonna let them receive these, and they can notify me as to whether or not they have an objection. If they don't have an objection, they'll just be entered as your exhibits, just as we just admitted the exhibits from counsel for Respondent. Okay?
All right, Your Honor.
Okay, so you go ahead and make arrangements to notify or to get that mailed out to the Attorney General's office. You have their address?
No, sir.
All right. Where can Mr. McFarland mail these exhibits?
Your Honor, you could mail it at 40 Capitol Square Southwest, Atlanta, Georgia 30334.
Mr. McFarland, you write that down?
I don't have a pen, Your Honor.
Can
Judge,
we
does
get,
he have a, does he have a copy of our answer that would have the address on it?
Do you have that, Mr. McFarland? Any pleading that has been filed by the Attorney General's office? Any communication from them?
Give me a second, Your Honor.
All right, take your time.
can we get somebody at the facility to provide it to them?
All right.
Somebody at the facility, I'm not sure who is the, possibly. I can contact the DOC and get him to make sure he gets.
Is it Georgia Department of Law, 40 Capitol Square, Southwest, Atlanta, GA?
That's right. And if you'll mail these exhibits to the attention of Ms. Sarfarazi.
No, the attention would be William and Finger.
William Finger?
Yes.
Okay. All right, anything else we need to take up?
Your Honor, I just wanted to get the court reporter's information and how they would like us to send our exhibits by mail.
Do you have our email information?
I can email her.
Yeah,
Please email.
I'll do that.
Rachel email her.
Okay.
Great.
Our habeas clerk's gonna email you and she'll provide you with the court reporter's information.
Okay.
All right. Thank you, Mr. Bowles. We appreciate you testifying. I know these are, I guess it's better than driving down to Reedsville this morning, but
Yes, it was, Your Honor. I appreciate that. Thank you.
I think we're going to try to adopt some of this technology that we have incorporated as a, I guess that's the silver lining to the dark cloud of COVID. It's made some things easier. I remember when I was practicing, I had to drive down to, I had one habeas hearing as a defense lawyer, Judge Joe Neville, the late Judge Joe Neville, Ms. Smith, you may remember him from Bullock County. That was years ago, but even, I remember I didn't get paid. A long trip and a lost day to go sit through a habeas hearing. I understand that. So maybe we can adopt some of this technology going forward. Thank you for your
I think that's a good idea, Judge.
All right, thank you. Mr. McFarland, after we've dealt with this issue regarding your exhibits, assuming that there's no objection, I'll get an order out to you, okay?
All right, Your Honor.
Thank you, sir. That
Thank you,
concludes
sir.
Anything else we need to take up?
I don't think so.
Why don't I call the balance of the calendar just to make sure that we're clear on, Pittman case was continued. Jonathan Maurice Johnson versus Terrence Kilpatrick. Now,
The proceeding over, sir, Your Honor? Excuse me.
yes, you're here. Hearing is concluded. Thank you, sir.
Put your mask on. Yeah, right over there.
All right, Jackson versus Brian Adams. Cuts like a knife. Brian Adams, I can't help. That's been continued. Lorenzo Wells versus Travanza Bobbitt has been continued. The McFarland case we just concluded, and Frankie Gebhardt versus Travanza Bobbitt. Let's see, that was one of Mr. Zell's cases, which was continued due to his conflict. All right, so who is this that we have here from GSP? What's your name, sir? All right, if you could ask them to unmute so we can hear you.
That's Lorenzo Wells.
All right, Mr. Wells. right, you're represented by Mr. Shepherd, is that correct?
Yes, sir.
French, Russian, or something.
Mr. Shepherd contacted the court yesterday and indicated that he needed more time to prepare. He was not prepared to go forward this morning and asked that your case be continued. That motion for continuance has been granted. So your case will be rescheduled at a time when your attorney is prepared to proceed. Okay?
Okay, this is a second continuance?
I don't know off the top of my head how many times your case has been scheduled, but your attorney moved for a continuance. Is that correct?
Yeah, I had, my first schedule was, May 26th.
Is Mr. Shepherd sick? All right, Mr. Shepherd has indicated that he will be prepared to go forward in January, so your case is being placed on my January calendar.
January 12th?
The 26th.
January 26th?
January 26th, that's right.
Okay.
Thank you, sir.
Yeah.
You done? Stand right there for me. Where your mask at? Stand right over there. Let me get you a mask.
Is there anybody else there from GSP that we need to address as far as continuance or anything like that, or is that?
I have Mr. Gebhardt. Hello, Jessica. Gebhardt.
That's one of Mr. Zell's clients, so.
They were supposed to put all this off.
Okay, well, I didn't get a cancellation, sir, but
Gebhardt, is that correct?
he's speaking to you.
Yes.
You can leave your mask off now.
Sir?
You're Mr. Gebhardt, is that right?
Yes, sir.
Okay, Mr. Gebhardt, you're represented by Mr. Rodney Zell, and Mr. Zell has contacted the court and indicated that he is not available today. He had a conflict. He is in court in Fulton County, so your case has been continued. It'll be placed on the January calendar.
January what, sir?
January 26th.
January 6th.
26th. January 26th.
Yeah,
All right, so your case is continued. Thank you, sir.
yeah.
You good?
Yeah.
Okay, you can. Make sure you put that mask on, Gebhardt. All right. Okay.
All right, we're actually not going forward with any other hearings. Are there any other petitioners there that we need to address? Apparently not.
Question. Kind of like getting a hang up on the phone.
Rick Wall doesn't have to fall on me for me to get the message. All right, so that looks like we have done all we can do here this morning. Anything else we need to take up, Ms. Smith, Ms. Sarfrazi?
No, Your Honor.
All right, well, thank you.
Thank you, Judge. Good to see you. And our regards to Miss Rachel.
All right, I'm going to swing by her house on my way back to Claxton and watch her rake some straw. So I told her in Atlanta she can get $5 a bale for it. She's threatening to make me put a bunch of bales in the back of my truck and take it up there. So. All right, y'all have a good day. Thank you.
Thank you.
Thank you.
Bye.